next topic is one that we've loosely called strategies and tactics, and we've been very fortunate to have both a terrific speaker and a great panel on the subject. It's so very, very hard to define strategies and tactics, and I was very pleased that Mr. Justice Gans could take the time out to speak to us on the subject. Many of you probably know that Justice Gans was formerly at the Fogler firm, and now that he's on the bench, it seems to me every time I'm in front of him, he has done business of one kind or another with every single lawyer who's in front of him. He probably is as well suited to speak on the subject as anyone I know. So, Mr. Justice Gans, thank you.
Can everybody hear me, all four of you? More importantly, can the producer hear me? What if I just move that over here? Okay. Okay. When Milt asked me to speak on this topic, I was a little concerned because I wasn't sure that I had any clue how I was going to be able to occupy some 30 minutes on the topic of strategy and tactics. I'm not sure that those who this panel would, or I'm actually sure that those who follow me in the panel will echo my remarks about having no clue. I suspect that each of Phil Epstein, who's here, and Marty Teplitsky have long held the view that I always have no clue about what I'm doing. And that's more to the point now when the two of them are on sides opposite in a piece of litigation. I suspect that my next ruling will underscore the belief that I still have no clue in what I'm doing. In terms of this particular topic matter, I sat down on a plane ride and I started to write out some of my thoughts in respect to strategies and tactics throughout the litigation process. And as I moved along the continuum, I take things in a very linear fashion, as I moved along the continuum from the commencement of the litigation process, that is before the issuance of the statement of claim, all the way to trial, I found that my notes occupied a ton of space, and I probably couldn't get past the pleading stage within the first 30 minutes. So you'll have to bear with me. I'm going to focus my attention on preliminary decisions. And those decisions, I think, are the critical decisions in terms of moving the case on. In my view, having regard to my experience as a litigator, the strategy and tactics that you employ aren't necessarily those which impact upon winning at trial. They necessarily involve consideration of issues that will enable the party litigants, your clients, to resolve the matters readily, speedily, and to everyone's satisfaction or dissatisfaction. I'm not going to embark upon any detailed discussion of the jurisprudence. I don't pretend to understand the jurisprudence that impacts upon this area as to whether you have causes of action and negligence in breaches of retainer and breaches of fiduciary duties. I will highlight a few issues in those matters, but you've already been inundated undoubtedly with all that erudite stuff which I really don't understand. There are some basic concepts that you have to understand in respect to the strategy before you embark upon it. Now, those really are, as they relate to the issues involving the suit against a professional. Again, the four areas that I see that people focus upon, generally speaking, are breach of contract or breach of retainer, negligence, negligent misrepresentation, and breach of fiduciary duty. You sue alone or you combine all four of them, if in fact you can. In my view, it requires an analysis from the get-go and as to whether or not your cause of action exists. And the analysis, in my view, again, whether or not the cause of action exists, should be performed often and in earnest and critically throughout the brief. Now, the reason I say it should be reviewed constantly throughout the brief is as follows. Number one, The knowledge of your case grows, indeed sometimes exponentially as the case proceeds. Number two, the evidence develops. Evidence that you didn't have at the beginning of the case, you now start getting throughout the course of the discovery process. The third reason for a critical analysis throughout is because your witnesses have a tendency at times to self-destruct or get better. Positions harden, sometimes positions soften. And when those things occur, that means you've got to be prepared to move from one aspect of your thought process to another. The final thing, and probably the most important reason why you should reevaluate the litigation process throughout, is that parties tire or become increasingly anxious of the process as the matters move towards the denouement. Now, the first two causes of actions that I described, and I have to remember what they are, breach of contract and negligence. You have to remember the seminal test. This is the only law I'm going to tell you about. The seminal test, which I'm sure you heard this morning. Professional competence is to be gauged by assessing the standard of care and skill that is possessed by a person of ordinary competence exercising the same calling. Now, I took that right out of Campion's book. I never quote from John Campion, but I think that's as clear a statement as you'd ever want to see in respect to the issue. Now, professionals, however, are not generally held to warrant that they will achieve the results that the client wants. It is essential, therefore, to obtain a critical and objective analysis of your case early on in the proceedings. And I mean even before you commence suit, if that's possible. In this respect, it's necessary to shop around for an expert sooner rather than later. Now, I've not used the term shop somewhat cavalierly. I've not used it cavalierly because I think you really have to go out and shop for an expert. The question is, how do you go about doing it? Depending upon the nature of the, it's about time you showed up. Depending upon the nature of the brief, will determine how you go and shop for, and he could have learned some of this before, will determine how you might want to go about getting these experts. The first starting point, in my view, to determine who's expert in the field is to go to your client. Now, I'm talking about situations involving construction cases where the client, who may or may not be a developer, has some sense of who's good in the industry, who's a good engineer, who's a good architect. The second good source of looking for experts is to go to other litigators. There are people whom you see reported in the ORs or the specialized reporting services whom you know are doing a lot of this work. Don't hesitate to phone any of these lawyers. First of all, it's a great ego boost when they receive a call out of the blue and a question is being posed to them as to who's expert in such and such an area. Go to classmates, go to colleagues, and you can also consider availing yourself of the compilation created by the American Trial Lawyers Association. My understanding is that's used for plaintiffs. There's a defense data bank as well put out by the Defense Research Institute, which I understand has a Canadian branch, and they're good for obtaining the names of Canadian experts in virtually every discipline you may want to proceed in. Now, the next thing you do, and this is obligatory, you have to obtain a copy of the CV of the expert. You have to personally review the CV, and more importantly, you have to ask the expert for names of referees. And by that I mean I want to know with whom that expert has worked so I can phone the lawyer and find out something about this expert. Now, what do I want to obtain? What kind of information do I want to obtain from my colleagues? Well, I want to know whether or not the expert is going to be responsive to my inquiries made during the course of litigation. I don't want that expert down at trial. I want to know something now about the cause of action, and I want to know whether or not this person is going to make him or herself available to fill me in on matters technical and on matters impacting upon the matters in issue. I want to know how good the person is in explaining the issues. Remember, many of you are going to be dealing in subject matters with which you have little or no familiarity. So you have to obtain basic information from the expert in order to understand the nature of the case. I want to know how good a writer how good a writer the expert is. I want to know if they're articulate, they can turn a phrase, they're verbose, they're too technical, they get too theoretical. The underlying principle in all this is again, the KISS principle, and you want to keep it simple for yourself, and you want to keep it simple for someone not as clever as you, those persons sitting on the bench. Now, the other thing that you want to do is to get some sense of how good a witness the expert's going to be. It may mean that you're going to need two witnesses. You may need an expert who's going to tell you what your case is all about and to educate you, and you may ultimately need an expert who's going to go into the box. They may be two different people. The first and foremost thing that occurs to me when I'm shopping for an expert ultimately at trial is to make sure that the expert is a good listener. Not necessarily a good speaker, but a good listener. It's indicative of whether or not he or she will listen to you as you're doing your prep work, whether or not he or she will be listening to the questions of counsel during the course of the trial, or whether or not they'll be listening to the judge pose questions. I want to know if that person is full of him or herself. I don't want to deal with someone whose head can't squeeze through the room. It's not necessary. There won't be room enough for both of us in the same room. Now, I want to know if that witness is self-effacing. I want to know if the witness is confident yet not arrogant. I want to, in some instances, I like to have a witness who's somewhat avuncular, you know, like you're some nice uncle who's going to go in there and explain things in very simple terms to the trier of fact or to a jury. I want to know if, in fact, the witness is someone who readily gives ground as opposed to obtains obdurate and stupid positions. And finally, I want to know whether or not the witness is going to be a charlatan. I don't want any other advocate in the box. I'm the advocate, sorry. You guys are the advocates. The witness should be a person who at least purports to give the court an objective foundation for the case. Now, it's important that you interview the witness. They go to beauty pageants just like you have to, as counsel, go to beauty pageants. And just don't take a witness as you find them. Make sure that you, in fact, interview the witness. Now, let's talk about some tricks that you can employ or some aspects of it that are important. Number one, I want to make sure that there's going to be some form of synergy between me and the witness, that I'm going to get along with the witness during the course of the preparation and ultimately at trial. Not to trot out old war stories, but I think that they are somewhat illustrative of the matters in issue. Had a case involving a crim neg causing death. I didn't do very much criminal. It was one of the few that I did. I needed a pharmacologist. Got the expert out of Addiction Research Foundation. I couldn't stand the guy. I absolutely despised him. He was so bloody arrogant throughout. Brilliant, but he was condescending. Readily made a determination that I could not deal with this witness. I couldn't deal with him in prep. I couldn't deal with him in analyzing and critiquing his report. And I was loath to take the witness through the course of trial. Consequently, I ultimately deferred to my co-counsel to deal with this son of a bitch, because I just really didn't want to have to deal with it, and I was concerned that my lack of understanding of this person would negatively impact upon my client's interests. Another thing you want to do when you're searching out these witnesses is you want to see what he or she has written. And you have to read what they've written. And let me give you an example. Had a case involving a stockbroker where each side retained experts in duties of registered representatives and brokerage firms as to the know your client rules. If I'm talking silly concepts, please forgive me. But essentially, you wanted to know what a broker does, what's the standard of care that a broker should utilize during the course of the trades that are taking place with the customer. In this case, the customer lost $8 million. My opponent's expert was the most, pleasing-looking, articulate gentleman. He was a colonel or a major. I think it was a major because the trial judge was also a major. And this guy, he came right out of Central Casting. Penciled mustache, gray hair, three-piece suit. He was terrific. I determined that he was also a member of the OSC on their tribunal, and that I determined as well on the night before trial that he had sat on some 30 decisions. We pulled all the decisions. You can now do it over the net. We had to go over there, pulled all the decisions. He dissented in every one of the decisions. Now, it was critical that I, as his opponent, learn that, because obviously the standard of care that he set up for the profession was not the appropriate standard of care. My opponent wasn't aware of it. Needless to say that his evidence formed much of the foundation of the trial judge's judgment, all to the negative. The other thing that you want to know about an expert, and one of the things that very few people ask their expert, is whether or not he or she is has been subject to any disciplinary proceedings. Simple question. Who would think about it? Example. Case that I sat as judge on most recently. A Mary Carter order was concluded between plaintiff and one of the defendants. Plaintiff gets defendant's experts, psychiatrist. Guy gets in the box, starts talking about the fact that he gave up his privileges at a hospital. He just threw that in. I'm live to that issue, having represented hospitals. No doctor in North America has ever given up privileges voluntarily. Never. Guy gets to be cross-examined. What happens? Now, doctor, have you ever been disciplined by the College of Physicians and Surgeons? Relevance. Well, we get into that kind of a duke out as to whether or not it is relevant. It turns out the doctor, the psychiatrist, had been sexually assaulting many of his female patients. Ultimately not relevant as to whether or not the plaintiff had been depressed at a certain period of time, but it surely knocked back the plaintiff's counsel. I mean, that plaintiff's counsel didn't know whether to wind his watch or do other things. And it upset the expert. He was visibly shaken. So, very simple test. Check out whether or not the expert has been disciplined. Again, the analysis that I talk about is something that you have to do early and you have to do often. Now, let's talk very briefly about learning the topic matter. Many of you, particularly if you're plaintiffs counsel, will not have specific or detailed knowledge of the subject matter that you are now litigating. You won't have the same leg up, as it were, as the counsel who do routinely architects, engineers, and doctors. I don't know if Colin Campbell's here. Doctors where McCarthy had a hammerlock on all the docs. They learned after several years from cradle to midlife what it was like to quote-unquote practice medicine. You don't have that advantage. Now, first thing I say, en passant, is don't be daunted by the fact that defense counsel or insurance counsel profess to know or may even know more than you on the topic. It just should be some form of incentive for you to go out there and learn tons about the topic matter. You can take your opponent's knowledge as a given, and then you yourself have to go out and bone up on the subject matter and learn about it exponentially. Now, I underscore one proposition, and that's a proposition that I learned once taking a statistics course, and that's the small world theory. The small world theory is based upon the notion that how many phone calls would it take to get to the President of the United States, having taken this course in the United States? Probably one if you know people with whom the President associates. But the small world concept in terms of experts is you can always and you should be able to, within 1 or 2 phone calls, find yourself somebody who's known to you or your friends or family who can edify you about the profession against whom you are seeking to proceed. For example, I'm sure if you thought about it, you could find a dentist you could talk to about dental procedures. Go to the office and see the surgery, see the operatory and see how it works. You can, if you're hard-pressed, find someone who can take you into a surgery in a hospital just to see the environment in which the person operates. You can, in my view, go out to and walk with and have drinks with any number of people who are not going to be your expert per se, but who will provide you with the backdrop against which your professional negligent case can be painted. And in that respect, you should take advantage of a run, a workout, a drink, a lunch. And it requires, in my view, a fair amount of time invested in this particular discipline to get the rudimentary aspects of the discipline. Again, you have to do it early, and you might have to do it often. That information as well comes in all shapes and sizes. And let me give you an example. If you have what do they call it? A bad baby delivery case, by way of example. Many of you may have only experienced the birthing phenomenon as an observer or as a participant, but really didn't pay close or rapt attention to the procedure, and that's quite understandable. So, in my view, and as occurred with me in a case, I knew that I would be hard-pressed, although I had the chief of obstetrics edifying me continuously about the process of delivery. I was somewhat embarrassed and reluctant to phone on a continuous basis on very simple concepts. Thankfully, my sister-in-law was an obstetrics nurse, and I spent time with her reading her textbooks, which, at the risk of denigrating anyone in the nursing profession, and my sister-in-law would kill me for that, it's written in much easier form than the straight medical text. And I had her walk me through the various stages of delivery so that I had some better grasp when I went to talk to my expert, as it were. So think about it. There are several ways to obtain or amass the information, and it requires some measure of creativity. The other thing that I suggest, and I've alluded to it before, is that you have to amass some knowledge, you have to pay a site visit. You can't learn about the profession of this individual without seeing the environment in which they work. I've talked about the surgery, I've talked about those procedures. You receive a report from an expert that talks about a binocular that they do the microsurgery through. Go out and see one. They are available, even if you have to go to a surgical supply store. The other aspect, by way of example, is you do construction litigation. You've got cases against architects and engineers. You can't learn about the screw-up unless you walk the site. Now, whether it's your client's site or some other site that's in relatively the same stage of construction, it's imperative that you walk the site. Well, let me give you an example. Situation involving soil compaction. I didn't even know what soil compaction was. I had no understanding, and I heard how they compressed the soil and obtained requisite PSIs, and who cared? Who knew? I didn't understand it. But I went out to the site, and I saw how the soils engineer put this little probe in the ground. This is precise science, I might add. Puts a little probe and jiggles it around. There it is. Says the compaction is there. Now that seems to me to be pretty Mickey Mouse stuff, but that seems to be the drill. Now, I never would have understood that drill without going out to the site, without seeing the dump trucks drop tons of dirt onto the site and seeing these big dozers come over the thing and tamp it down. It's no more sophisticated than that. It's pretty scary when you think of it. Required a site visit to understand the circumstances within which these engineers were working. Again, site visits, early and often. Now, let's talk about another early on issue. And the early on issue I like to focus on is damages. Again, the professional is not a guarantor of success, and the question really is who is at fault. I try and do a cost-benefit analysis as best as one can early on in the piece, just to make sure whether or not the game is truly worth the candle. If my client is going on a building case, my client is going to undertake remediation, I put all the defendants on notice on the remediation. Come and see the project because we're going to do X, Y, and Z, and we're doing it now. Now, the purpose of that is you get many of your opponents are reluctant to get involved at that stage. My view of it is, and I've never had to test this theory, and I guess I never will, my view of it is that if you ask someone to come to the site or to comment upon your remediation process, and they fail to do so, an estoppel that action and activity may give rise to an estoppel. Again, on damages, early on in the piece, get a hold of the defendant's insurance policy. Find out what the limits of the insurance policy are and what the deductible is. That allows you to get some assessment of how much the named defendant, other than their insurers, is going to have to kick into the resolution. Important to know in terms of gauging where you're going to determine into whose pocket you're going to have to dip. Remember, the policies are producible under the rules. Closing in on the end. Pleadings. I'm not going to talk in any detail about the cases which I'm sure you've been alerted to. Central Trust and Refuse, BG Checo International, Queen and Cognos, Edgeworth Construction. I'm sure they're all in the material. So I'm not going to talk about it. But before you plead, please, if you're not going to get bullet and leak, please read at least the head notes so you understand how the case is to be pleaded. I'm repeating this yet again. I'm tired of seeing shitty pleadings, and I'm telling you that the pleadings that I see in general leave something to be desired. And it comes about as a result of not, I think bullet and leak's a great pleadings text, but it comes about in not understanding the nature of the beast, the facts that lead to the conclusions that you ultimately have to prove. If the matter is in contract, plead it in contract. If the matter is in tort, plead it in tort. If you're not sure, you haven't got the full contract, or you don't know and the client doesn't know, plead both. You don't want to be caught short 6 months down the road beyond the limitation period for not having put both in the pleading. Real simple point to plead: breach of contract and/or negligence. I know that some of my colleagues don't like that and/or proposition. I still think it's right. You may not know whether or not there's privity of contract between you and others up and down the food chain of defendants that you're suing. For example, in an engineering case, you may sue the prime consultant, but there may exist a question as to whether or not the subs are his subs or have a direct contractual relationship with you. That's an important issue because of the doctrine set out in one of the cases, which I can't remember. I think it's Edgeworth Construction, where you may not be able to go after sub-engineers for negligence because they are protected by some limitation process within the wording of the main contract. Okay. Right. Let me just deal briefly with breach of fiduciary duty and negligent misrepresentation. Some of the members of the General Division are tiring of seeing these two causes of action pleaded when the causes of action don't exist. You have to be pretty mindful of what the law provides. Let's deal with breach of fiduciary duty. Yes, the examples of breach of fiduciary duty have not been closed off. Every court in the land has expressed that. Again, my view is, depending upon the professional against whom you wish to proceed, read Madam Justice Wilson's decision in Freeman Smith, read the head note in Norberg and Weinrib, you fall asleep reading the judgment, and go back to reading Hodgkinson and Sims and find out whether or not the facts upon which everybody reaches for their pockets. The facts upon which you're proceeding lends itself to a cause of breach of fiduciary duty. Negligent misrepresentation. Take a look at the Hercules Management and Ernst & Young case. You have to understand the concepts of proximity and reliance. Again, do a critical analysis early and continue to do that analysis as the material starts to develop. It may be that the cause of action that you have included just isn't there, so why focus your resources on something that's going to be a dead ender? All right, word on jurisprudence. This is applicable to all lawsuits, and the further I moved away from taking the subway to work, the less I was current about reading the law. I did, however, when I was flipping through the ORs and looking to see who moved where, I did, however, look at the index, and I was able to determine from the topic areas that, oh, negligent misrepresentation. Rip out the pages of the OR applicable to that case, throw it in the file to be read at my leisure, as it were. Okay, time doesn't permit me any more detailed analysis, except to articulate one last issue, if I may. And that is the most underrated step in the proceedings, in my view, are the discoveries. And in my view, counsel have to spend a lot more time doing discoveries. Now, I'm telling this to the plaintiff's counsel because it holds true. Defense counsel, in the 25 years I practiced, were rarely prepared as well as I was. And I think that that's an important leg up, because I understood that my case was going to settle before trial, and they were still learning the file sufficient to render one of those long-winded reporting letters to their clients. So take advantage of the fact that defense counsel, Joe O'Brien's going to kill me for this, but he was there. Take advantage of the fact that defense counsel aren't going to be as prepared as you, and learn the documents, learn the issues, and go after the plaintiff with full vigor at the discovery stage. Now, it's important that you don't use the discovery to learn the case from ground zero. It's a total waste of time if that's what you're doing. If you're just pawing through the documents for the first time and getting a feel for the case. If you come in that respect, don't bother going to discovery, because you're going to be wasting your time. Have more than a nodding acquaintance with the case, and use the time to pin your opponent down. The flip side, of course, is that defense counsel shouldn't be using the discovery to learn the case. And apropos of that, in my practice as a plaintiff's counsel, I always prepared my affidavit of documents right away. I always served my affidavit of documents, and if I couldn't get agreement with counsel, I served appointments. And I completed my examinations for discovery before the defendants got off the ground. Why? I want to get this case on for trial. I want to get into, in the old days, Joe O'Brien to beat some sense into people to resolve it. Now Warren Winkler and all the other judges across the street who are inclined to resolve cases early. I want to get there. And if the defendant hasn't examined my client, I don't care less. Now, the other end of it, too, is at the conclusion of the discovery, and I didn't do this with great consistency to my everlasting regret, but at the conclusion of the examination for discovery, know that the defense counsel is going to send out one of those long-winded detailed letters handicapping the case. My view of it is that you either do it by way of a reporting letter or you prepare a pretrial memorandum right away. You finish the discovery, the case is not going to get any better. Your client may self-destruct, but I'd prepare a detailed pretrial memo, throw it in the file because you may not be ready for it, at least analyzing what the strengths and weaknesses of the case are, and then you can ferret out that information for purposes of the formal pretrial memo and boost it in sufficient fashion to present before a pretrial judge. Remember that the better your, and I just say this in passing, remember that the better your pretrial memo is, the better you'll be able to persuade the pretrial justice to go along with your position. And you have, at that stage, another person in your camp trying to persuade your opponent to settle. So if your opponent's pretrial memorandum isn't worth the paper it's printed on, take advantage of it by you making sure that yours is complete, replete with cross-references and important documents if that is the nature of the case. That's it. That's all I want to talk about, and that's all the time will permit, and I got to go do a motion. Thank you very much. If anybody wants the paper.
Thank you very much, Justice Gans. I'm very grateful. We're all very grateful that you could take the time. We're fortunate to have as our panel on the subject of tactics Mr. Justice Colin Campbell, Marty Teplitsky, and Phil Epstein.
I could think of all kinds of analogies sitting between these guys. Well, in our wonderful hour of preparation last night, we did come across 2 or 3 things that I thought we might each start off with 2 or 3 responses to some of the things that have been raised by Justice Gans, and then let it go from there, and you can feel free to interrupt with questions whenever you want. And so I got 2 or 3 to start off with, and I think each of us have, and then we'll go from there. And let me just start off this way. One of the things that occurred to me was a tactic that used to be used to great effect by Ken Howie when he was suing doctors. Invariably, Ken would write the professional before he started a lawsuit and say, please give me an explanation about X, about what you did. And it's a very interesting tactic no matter which side you're on. And Karen, you don't have to worry, I haven't totally jumped over. I now have an objective view of professionals on both sides. But the interesting thing is, from the plaintiff's point of view, what better way to see if you can get some kind of an explanation or non-explanation that you may be able to use later. From writing the professionals, that my client's got a complaint about X, what do you have to say about it? I can tell you from my life of acting on the defense side, it caused one pause to see how one should respond, because I do think, did then and do now, that in most instances the professional has some duty of professional responsibility to make some explanation to the client, and what you do and how you do it may indeed alert the professional to get a hold of his or her insurer faster than would otherwise be the case. And that's all to the good, because out of that experience you could find some cases that are resolved even before action that might otherwise not be the case. Secondly, I think that all too often some people on the plaintiff's side aren't sure why they are suing. There's something that's gone wrong. And they want to cast the net as broadly as they can for things that I'm sure Phil will speak about. They haven't really thought out, why do you need or want the professional in the action? Is it for discovery? Is it because the professional's a deep pocket? And there may be alternatives that indeed, if you get a hold of somebody and talk to them before you sue, that you may in fact be able to get the professional on your side. There may be different ways to achieve the goal, even if you have to sue. I'm sure people are familiar with things called Mary Carter agreements and whatnot, because out of the process of having to sue the professional, and I saw one or two of these in my practice, is the circumstance that alerts somebody else to sue the professional out of the same set of circumstances. And in the materials, I'm sure you've heard people discuss the growing area of third-party liability by professionals. And sometimes that only arises from the fact that the professional was included in a lawsuit in the first place, and it may not inure to the benefit of particularly a plaintiff if you could otherwise make some kind of an arrangement deal or something, or even await the determination of responsibility of the professional. Last on my list to start this off is that you can see how with the scope of our Negligence Act that there is an encouragement to include a professional amongst the defendants, because 1% liable, he or she is jointly and severally liable for all of the damages except in certain circumstances. And you can see why the professional then, and particularly insurance organizations, will attempt wherever possible to move by way of summary judgment, even if there's a low chance of success. But as long as there's some chance of success, if you've got somebody who's got the 1% chance of being found liable and a 15% chance of getting out of the lawsuit, they'll bring that motion. And some people who commence their actions, and I'm now seeing these as a judge, commence their action, don't have their ammunition well set up to protect themselves against a summary judgment application. So if you're going to sue a professional, you better know what you're about in the way that Justice Gans was saying. So those are 3 or 4 things to start things off. Who's next, Bill?
Thank you, Your Honor. Following up from that, I'd like to just conduct a brief experiment, if I could, but it requires all of you to participate. On the theory that all of you are lawyers, how many of you, and please put up your hands, have carefully read the LPIC policy from cover to cover? So it's about half. I have my experience in this particular area is limited solely to defending LPIC claims for about 25 years. I would venture to say in about 95% of the cases in which the plaintiff is suing, the plaintiff's counsel has not read the LPIC policy, and in particular has not read the LPIC policy of late. It is important, if you're suing a professional for the purposes of getting at a deep pocket, which is often the reason, that you at least understand when the deep pocket is available and when it's not available, and that you cast your claims properly so as to either to attract coverage or not attract coverage. I would assume in the vast majority of cases your intent in suing a professional is to ensure that LPIC responds to coverage. There may be the occasions that you deliberately do not wish to attract coverage so as to force the lawyer to either defend personally or be at risk personally. And if you are using that tactic, which is an interesting one from time to time, one has to also frame their claim so that it does not come within coverage. What I refer to particularly is the fact that LPIC or the policy essentially responds to claims of negligence for errors and omissions, which would include breach of fiduciary duty, but it does not respond to fraud or malicious acts of an insured. A deliberate malicious act is often claimed against a professional, particularly a lawyer, such as abuse of process. This does not attract coverage. In addition, people seem to think that because the client was a corporation and that the individual the president of the corporation may have guaranteed the corporation's debts or some other area, that there is more than one claim and therefore more than one policy limit available. It's important to understand how the policy is worded, that what the policy limits are, what the aggregate limits are, so you don't try to recover in areas which are not possibly available for indemnity by the insurer. You must understand from the policy how partnerships work in terms of LPIC coverage and what are the consequences of suing a partnership. What happens if one of the partners is guilty of fraud, but the other partners are innocent of the wrongdoing by the other partner? Is there or is there not coverage, and how do you wish to frame your claim? Justice Campbell talked about not making sure that your claims are too wide, and yet Justice Gans talked about making as many alternative claims as you can. Now, it seems to me that you can reconcile those two positions. It may well be that you would want to sue a lawyer for breach of contract, negligent misrepresentation, negligence, a breach of fiduciary duty, but you don't want to mix that in with fraud or an intentional or malicious act, because it has different implications for the person who's conducting a defense. Now, where the insurer is concerned that in the investigation of the claim there may well be a policy breach, the insurer will defend under a non-waiver agreement. This is, I think, something that it's important for you to understand as plaintiff's counsel, but also as defense counsel. If we think a breach has occurred, we will ask the lawyer whom we're defending to agree that we can defend without prejudice to our right later on to deny coverage. Although LPIC means different things to all of you, the fact is that LPIC has become, since its regenesis a few years ago, much more of a lawyer-dedicated organization, and it rarely, if ever, denies coverage, and it only denies coverage in the clearest of cases and when there is merit to a denial of coverage. It is therefore important to understand when you're suing a professional as to whether the policy is in force and whether the insurer has taken a non-waiver position and what the basis for that non-waiver position is. The more significant the basis for the non-waiver position, the more risk you run that at the end of the day you will have a paper judgment. So it's very important to understand on what basis the insurer is defending, and you can't always assume that because the insured is defending that the coverage is available. It's also important to look at the policy in order to understand runoff coverages and what happens if you're suing judges. Colin left behind a lot of files at McCarthy's when he left, and he's got a limited policy. So if you go after him now, although he's got coverage, he's got very limited runoff coverage. And you have to understand how your claim affects the policy limits and what that forces us to do when the claim is in excess of the policy limits. So I begin any discussion about professional liability in first having a clear understanding of the policy and making sure you've reviewed it afresh. Now, in relation to Justice Campbell's comments about writing to the lawyer, you should understand that there are a lot of claims, particularly in the smaller end range, where you will do much better with direct contact with the professional who has made the error than you will in starting a lawsuit. Under the policy, if you make a claim against a lawyer and he has to defend, if she files a statement of defense, then she has lost half her deductible. If he then goes to discovery, he's lost the other half of his deductible. And if a claim is made and it's the first claim, then the lawyer has a levy for 5 years at $2,500 per year, which by my count is $12,500. And if the lawyer is unfortunate to have 2 claims in the past 5 years, the levy will be $25,000. So if you are suing a lawyer that's had 2 claims, the first $30,000 is going to come out of that lawyer's pocket. And if your claim is for $15,000 or $20,000, the wisest thing is to begin a negotiation and a discussion with the lawyer in an attempt to resolve that matter. Although the lawyer will have to give notice to LPIC that there's a claim, lawyers will frequently ask for permission to waive coverage if the amount is going to be less than they will pay out of their pocket on a claim. So people should not rush off to make a claim, attract the defense, attract the costs, and then find that LPIC and the lawyer are dug in, because instead of your claim being at risk, the lawyer is more worried about the lawyer's deductible and the lawyer's levy. The most difficult claims that LPIC counsel seem to have are claims in the $15,000 range, because we want to settle them quickly because of the rising costs, and the lawyer complains that the only reason we're settling them is so that the lawyer can pay them personally through his deductible or levy. That becomes a very big problem when we have disputes about liability, because the vast majority of professionals believe that they're not liable. It doesn't matter what error that they may have made or what omission. They don't believe that this could possibly have led to liability, and in any event, if it did lead to liability, it wasn't below the standard of care. So you don't really have to search title unless it's an out-of-town property, or you don't have to start a claim within the limitation period unless it's outside Metro Toronto, and things like that. So small claims are very difficult for lawyers, and you may be able to make more progress in resolving them with direct contact.
Let me just add one thing to that, Phil, just as a follow-up, because I think that's very important. In the cases that I have been seeing this fall as a new judge, both in pretrial and at trial, often the lawyer's costs are in excess of the amount in issue. And that arises because often the plaintiff's lawyer hasn't thought his or her way through of what they're trying to do, and by commencing an action and starting a route that is going to incur costs, you may be turning on a tap that you can't turn off for the very reasons that Phil has said.
Yes, that's very true. Before, we used to send a letter saying we'll allow you to discontinue without costs, but quite frequently our clients now say, well, you owe me a duty as well, and you're not going to discontinue without costs. I want my deductible back. So you've started a snowball rolling down the hill that you can't stop. So the idea of adding a professional to see what falls out is not necessarily a good idea if you get a stubborn professional who won't let you drop him or her without at least covering his deductible.
Marty?
Two little points about experts. Justice Gans mentioned finding out about the expert's background. A useful way of doing that is on your computer. Look them up on Quick Law. Find out if some judges said some nasty things about them in the past. That may be an expert you don't want to use. Alternately, if the other side's experts have been commented upon, you may be able to use those comments to your advantage. So I think that's a helpful thing to do. The other thing about experts is that obviously in these professional liability cases they're extremely important, but most of them don't have the skills to write reports that are, in my experience, cogent. So that creates a bit of a problem for lawyers in that, on the one hand, I think you have to help them write their report. You have to help them analyze the case. You may have to explain to them the legal basis on which the liability issue depends, or you may have to explain to them how damages are calculated or what the theory of damages is that you want their opinion on. So you're going to have to assist them. There then becomes a question as to whether or not that assistance is a proper subject matter of cross-examination at trial to undermine the credibility of the expert. Presumably, he will be wise enough not to have kept his drafts, but then again, that might be commented on adversely. He's probably going to have to produce his file. If anybody is even marginally on their toes, they're going to make him do that. So it's an area that is full of problems for lawyers, but I come down, in my view, you have to assume that there is going to be disclosure of the fact that you've been involved, but nevertheless, if you're not involved, you're going to find that most of your experts are going to get chopped up by any decent cross-examiner. One other area I wanted to speak about that Justice Campbell touched on, and which I think is very, very central to doing these kinds of cases if anybody wants to do them, and that is money management. Too many cases, in my experience, start off with rapt enthusiasm and the quick expenditure of the client's retainer, and then they come to an abrupt halt because the client has run out of money or isn't satisfied with the progress that's been made for the money that the client has spent. A lot of what Justice Gans said, all of it was very useful, but it may not always be available to you as plaintiff's counsel unless you have decided that you're going to carry the file, if not all the way up the hill, a good part of it up the hill, because his is a counsel of perfection. I know that's how he practiced. But if you don't have clients with deep pockets, I think decisions have to be made, and that's why we earn the big bucks. Not suing as many people, making our claims narrower, not spending as much time at discovery, actually deciding what are the issues in dispute that require discovery as opposed to looking under every rock. So I always talk to my clients about how much money they have to spend. I tell them how far that's going to take them, because you obviously in these cases the defendants always have deep pockets. Their willingness to settle may not be fabulous. They always see a policy reason for not settling. It discourages others because they know they have to fight it out. Commercial business people won't take that attitude. Everybody that you sue in a professional negligence case is a professional defendant, in the sense that he's represented by people who make their living defending cases or dealing with insurance policies. So you have to assume that you're there for a long time. You have to talk to your client about who's going to fund this, how far it's going to take him, and that if you expect to be funded all the way through, which is perfectly reasonable, he understands that or she understands that, and it isn't a big shock. I now reduce all of this to writing so that there's no arguments, disputes later. Now, I sometimes fund cases myself, or parts of them. But if it's a kind of case where I expect to be paid all the way down, I get a letter signed by them as to how much money I think this is going to cost them, and et cetera, et cetera. There's no point starting these things in the hope that you're going to get an early settlement. You might get an early settlement, but if you happen not to get an early settlement, you dump the plaintiff and you haven't been informative with the plaintiff, you're also going to get a letter to the Law Society by way of complaint. And nobody needs those, needless to say. I think the Law Society may be working on guidelines on this very subject, because one sees it all of the time in family law, in these kinds of cases, that someone got off quickly but didn't go very far with the lawsuit. So in that connection, I mean, obviously if you can get yourself into some form of ADR, I'm not as optimistic about pretrials as Justice Gans is. I think most people don't pay too much attention to them today unless they know in advance that they're getting a judge that they think, you know, is knowledgeable in this area and doesn't have 8 or 10 other pretrials to do that day and can be of some assistance. But there are lots of people practicing in Toronto now at ADR chambers and other places where you can get early neutral evaluations or mediation help or whatever. And I think that by and large, from a plaintiff's perspective, that's a better expenditure of funds than just about anything else is, to try and get there as early as you can, try and get your case settled as early as you can. I think we as plaintiff's counsel will make more money doing that, and the client is going to be way happier.
Phil, you had a comment you want to make on experts.
Well, I think Marty's raised an extremely important area with respect to experts, and perhaps, Your Honor, since you've had a long experience in this area, since you, in virtually all of your medical malpractice cases, you called an expert. I would have thought that there's no privilege between the lawyer and the expert once the expert gets into the witness box, and therefore it is generally a defense question. It's always one of mine, is let me see your file. And I then take some time to look at the expert's file, and then I see not only Mr. Teplitsky's handwriting, I see the first draft, and I recognize Mr. Teplitsky's handwriting all over the first draft. And then away we go with the fact that the expert didn't write the report, Mr. Teplitsky wrote the report. Now, the other alternative is to have the expert get in the witness box and say he doesn't have any drafts, which only takes a few questions to establish that he did have drafts, but he doesn't have them anymore, and it probably emerges sooner or later that Mr. Teplitsky told him to destroy the drafts. God knows why he would have told him to destroy the drafts. And we get into the issue.
Lucky I can make a living with this.
Right. So the issue is how pristine is the expert supposed to be? Or put another way, Your Honor, what did you do then and what do you expect now?
Well, what I did then was read some law that said there is a privilege, but then conducted myself as if there wasn't. Because I think this is a murky area of law, and you can find some cases that do uphold a privilege, but I'd be careful about relying on them because more trial rulings than not allow Mr. Epstein into the file, and that was kind of the way that I conducted myself as a lawyer, presuming that he'd find a way to do that. In strictness, I think that the opposing side is entitled to know the factual basis and where the facts came from that the expert assumed for the purposes of the opinion. Beyond that, the communication as between counsel and the expert, beyond the factual base, I think should be privileged, but more often than not, it isn't. So and if I helped, let me tell one little war story, because this one it panicked me at the time. I was in the middle of a trial, and this was before we had the 10-day rule, and the situation got itself, and I had to deliver an expert report. I was having to deal at some distance with the expert, and I called him on the phone, and this gentleman said to me, and his English wasn't his first language, and this is probably the reason behind it, but he said, well, look, you tell me what you want me to say in my report, and I'll look at it. And I thought, oh my God, what am I doing by doing this? In fact, I ended up doing that. He made some changes to it, signed it, and it went ahead. And he was cross-examined and asked what happened. He said, why happened? He said, well, how come that's your opinion? And he said, I knew what I was going to say. I needed to know from what he was going to tell me the issues were and how I should deal with them, whether I could say my conclusion. And he was perfectly creditable about it, so I don't see any hesitation in the appropriate case if an expert needs assistance, but don't hide behind it. As to drafts, that's another situation. Depends why you're changing the draft. If the expert knows why that's being done and whatnot, I don't see any reason. Let them see the file. So my basic defense was assume that the file was going to be looked at and tell the expert in advance, and let the expert make his or her determination as to what they want to keep in the file.
I think Justice Campbell's accurately summarized it. You can find Canadian cases that say there's a privilege. Most judges, I think, today don't accept that. The Americans certainly don't accept it. And in any event, as a practical matter, a lot of judges think that when experts are talking, it's just the lawyer talking anyway. So, you know, it only, to my way of thinking, adds more reason to make sure that your expert's report is in good shape. Not that it's necessarily saying everything that you would love in the best of worlds to say, have it say, but that it is organized, that it is rational, that he can support it, that it isn't dopey, that he isn't going to be like evaluators. If you get evaluators, expert evaluators reports, I mean, they're the craziest things in the world. I mean, it's hard to find one that isn't very attackable, that, they can't, I've never actually seen, other than one appraiser in Toronto, whose reports could be supported, that he can support them, because he just is a very clever guy who only writes things that he believes in, does good research, and isn't trying in a predetermined way to come up with a particular result. So it's an important area with a lot of pitfalls, but If you file reports that are full of holes, that's going to blow your case for you.
Well, surely there's some middle ground. I mean, we're all aware that there's an increasing desire on the part of plaintiffs to serve jury notices in professional liability cases. There's a growing number against lawyers. We're frequently successful in striking them out, but not always. And it seems to me to be devastating to have an expert testify in front of a jury that's got your fingerprints all over the report. I think you should ask yourself, whenever you're helping an expert prepare a report, about what's this going to look like if everything comes out of your file and is shown to the triers of fact. And you should be very careful in your correspondence with experts and very careful with drafts, and you should always operate on the assumption that whatever you do is going to come out.
The easiest way to make sure that the expert's got a good, clear file is to write a very good, clear letter of instruction and say to the expert, we are enclosing the following documentation and information and list it out in detail, and based on your review of that, we would like you to address the following issues or questions and put them in the way in which you best think will suit. And in that instance, when I was in practice, would often have some discussion with the expert about the area so that he or she understood when the letter went with the questions what it was that was being addressed, particularly if you had to put it in the language that was in the expert's field and not your own. And therefore, you've got a clear letter instructions well set out, because I can remember numbers of times being able to cross-examine experts on the basis that they couldn't remember what they were given or not given. They didn't have in their file the examination for discovery, so they never presumably read it, and one could make a great deal of hay of that. So setting the thing up in a way that your expert knows what they're getting and what they're being asked is probably the best way to do that. I got one other thing for you, Marty. You're suing a professional, be it doctor, lawyer, engineer, whatever. Is it advantageous or not advantageous to your client's position to try to start some disciplinary process at the same time? And if you do, what use can you make of it?
Well, I have an absolute rule against that. Personally, I don't report anybody unless the rules require me to do so in those very narrow cases. And I don't report people to the income tax department, and I don't report them to the police. So if my client wants to do that, then he can do whatever he likes on his own, but he's not getting any help from me in doing any of that stuff.
Phil, from the defense point of view, what do you...
Well, from the defense point of view, we see very commonly in claims against lawyers that lawyers are sued ostensibly because they breached a rule of professional conduct. And the actual pleading is that they're somehow liable to the plaintiff because they breached a rule. This frequently occurs in third-party claims, and particularly so in family law, where the husband sues the wife's lawyer, alleging that in the conduct of the case, the wife's lawyer breached the rules of professional conduct, and actually sets out with specificity what rule is breached. And sometimes the rule is in fact breached. That is not in Ontario a cause of action. At least two cases, Brignolio and Desmarais and Teitelbaum and Elkin, both unreported, but one of them affirmed by a single judge of the Court of Appeal, both stand for the proposition that a breach of a rule of professional conduct is not a cause of action. It gives the law society the right to discipline its member for the breach of that rule, but it doesn't found a cause of action in a third party. Now, the reason people sue that way is because they recognize that the wife's lawyer did not owe the husband a duty of care. And there are still some out there who believes that he does. There are many cases decided in the last few years that have reiterated that the one lawyer does not owe to the opposing party in an adversary system of duty of care. and it does not give rise to a cause of action if the plaintiff feels aggrieved by that lawyer's conduct where the lawyer did not breach a duty of care. But what has become a very common tactic, one more to be condemned than used, but occasionally used for tactical reason, is to sue the lawyer on the other side for abuse of process. This is a nominative tort. It's not in the negligence realm. The policy does not respond to it, although if the lawyer has partners, the innocent partner coverage will kick in for the other partners. But it has the effect of driving the lawyer off the file and is sometimes misused for that purpose. Although occasionally there have been successful claims for actually not only suing another person for abuse of process, but involving the lawyer in the claim as well. Again, this is another area where family law, the heat and emotional toil of family law seems to attract the worst sides of people, and lawyers are quick to try to drive, sometimes quick to try to drive people off the file, and they use that technique.
Well, just think about it for a moment, listening to what Marty and Phil have to say, because if you're contemplating suing a professional and think you may get a little more leverage by doing that, many professionals still regard their regulatory body findings as being very important to their careers, and the mere fact that you make those allegations will make that defense all the more vigorous and all the more complicated, and preclude what Marty would like to do, and that's get to an early resolution, which may be by the profession themselves or with their insurer. But if you've got a potential claim out there for professional misconduct on top of it that won't go away that easy, the case may be a lot more difficult to deal with.
Needless to say, I mean, allegations of breaches of the rules of professional conduct are obviously relevant if it's your lawyer who has breached them. I mean, and they have a perfectly proper place in a pleading to establish a standard of care, a breach of the standard, and some causal connection if it exists between the breach and the damages. Just one little point I meant to mention earlier and I forgot. You know, it's not only the Law Society that's busy pumping out endless volumes of literature to instruct us on how to act. Virtually any professional body, person that you sue, real estate brokers, appraisers, it doesn't matter, engineers, they all produce literature that you can easily access, not very expensive, tells you or them the right way to do it, and allows you to get instructed fairly quickly if what conduct you're complaining about, whether or not it complied with the literature that the professional body is putting out. So I find that a very useful, cheap way to pinpoint departures from an appropriate standard of care.
In fact, many associations, the Appraisers Institute of Canada, the Ontario College of Psychologists, a number of other organizations not only have rules of professional conduct, but they have rules for what their reports should look like. And accordingly, when you get an appraiser's report, or particularly a psychologist's report, you can compare the report with whether they violated their own rules in accordance with preparation of reports. I remember a recent case where there was a battle of the appraisers. One of the appraisal reports violated about 6 out of the 12. Although it was a leading appraiser, 6 out of the 12 requirements for an appraisal report. And as a result, the appraiser got shaken and lost a great deal of credibility. So it's useful to pull up these reports from these organizations and use them as a checklist to see if the author complied with his own college requirements. There was a question?
Can you speak up so we can hear you?
I'll repeat it for the producer. How would I define abuse of process? It's akin to the nominative tort of malicious prosecution. What it really is the civil side of malicious prosecution. So put another way, it's the nominative tort of malicious civil prosecution, which now seems to have taken on the name of abuse of process. I don't think they're indistinguishable. So that is, you participate, you encourage your client, and you prosecute a claim when you know, or ought to have known, that the sole purpose behind the client's claim was a malicious purpose. Now, it's not your requirement as a lawyer to investigate whether the client, I'm sorry, it's not your job to judge the validity of the client's claim. The rules of professional conduct say that you put clients' position forward fearlessly, without favor, and so on. But if, in that rare case, you knew that there was no cause of action, and that you knew the purpose of the claim was maliciously motivated, if you participate in that, you may well be party to an abusive process and be subject to a claim. And by the way, if you are subject to that claim, it will be only because you will have been found to have been maliciously involved with the other party in the claim. As I said, you will find some listed cases of abusive process. They're very rare because you actually have to go so far as to find that the lawyer was aware that the claim was ill-conceived and motivated by malice. And lots of us are aware of ill-conceived claims, but not aware that the client is putting forward them on the basis of malice. It's not a legitimate claim prosecuted abusively because the remedy is in costs. And many of these claims, the ultimate result is the judge says that was a matter for costs in that action. But it is akin to malicious prosecution, where not having been home or assaulted, you charge your spouse with assault, and they're acquitted, and you're sued for malicious prosecution.
Got another question up here.
Well, I think you can only get that file under the rule that provides that you can get third-party documents, provided that you can show the need for third-party documents. I think it's going to be very hard to get that file, ITSIC, at that stage, but certainly on my subpoena for trial, if I knew the plaintiff was going to be calling that expert, I might... Well, I probably wouldn't want to issue a subpoena for the file because that would just tell them where I'm going. So I'd probably wait for the plaintiff to show up. And usually what you do is you say, you haven't got your file? Well, it's 3 o'clock. I'll go as far as I can, Your Honor. If you're really looking for favor, you say, my lord. And can we carry over until the morning, and perhaps we'll interrupt another witness and you can come back with your file. If you send the subpoena out in advance for the other side and say, bring all your file, your previous drafts, your letters from Mr. Teplitsky, so on, Mr. Teplitsky will spend the evening huddling with him and try to fix that all up. So you don't want to, he'll have a line.
It's amazing your grasp of these nefarious activities.
Well, I believe, Marty, that you would properly prepare an expert, and I believe there is an irresistible impulse amongst all of us when producing an expert to make sure the expert gets it right. And in giving way to our irresistible impulse to make sure the expert gets it right, you can get into trouble. I remember a very important case to me recently where the doctor produced, if you can believe this, a 200-page report. And we did some very, very serious surgery on that report. Because we needed this witness because of who he was, but we could not live with that report. And we ultimately gambled because of who we knew was on the other side and where we thought the case would go and how far they'd get into it. But if I had had Marty or Colin on the other side, I would have gotten rid of the expert and got rid of that report and started over again. I would never have done serious surgery on a report when I'm faced with a skilled cross-examiner on the other side, because they can just wreak havoc, absolute havoc.
Just let me finish off with one, and we'll go over here as a question. Putting my judicial hat on, the question of privilege is more likely to be upheld, I think, at a motions level than it might be at trial, because the trial judge is, in my view, probably the appropriate person to deal with that. Yes, unless it's waived. So if it was resisted, then and privilege claimed at that point in time, more likely to be upheld. And you don't want to get stuck with that as a precedent going into a trial. Over here.
How is your thinking on the conduct of a solicitor's negligence case affected by an assessment of the solicitor's account going on in a parallel way?
Well, that's something of which you have to be very careful of because of Justice Creever's decision in Somebody versus Keeley. Right, all right. That says that any intervention by a judicial officer on the same matter gives rise to issue estoppel. So theoretically, if a master or assessing officer is assessing the account and makes a finding of fact, it is not open in the subsequent proceeding to interfere with that finding of fact. And that's kind of devastating. As a good example, so you understand the issue, in Keeley's assessment, he allegedly failed to show the wife an offer to settle, in which she would have recovered dramatically more than she did receive at the end of the trial. At the end of the trial, the wife was sitting in the courtroom. The offer to settle was revealed. She never saw it before. She tried to jump over the court bar and strangle her lawyer. She was restrained from doing so and instead assessed his account. The lawyer didn't tell anybody the account was being assessed, and the master found as a fact that he did not show her the offer to settle. He was then sued for quite serious damages, and I got the file. And the first thing I did was plead that he showed her the offer to settle, because he says he did. They struck that, to my horror, they struck that out of my pleading, because they found that that had already been found by a judicial officer, so it wasn't open. So what I do now is when I get a call from a lawyer who says, I'm assessing the account, it's clear they're going to raise negligence, it is possible to move the assessment before a judge. And you move the assessment from an assessing officer or a master to a judge, and you may then have to go in and defend, because you run the risk of an adverse finding of fact that you can't afford and will bind you on the subsequent claim. So, and I would say maybe 10% of negligence claims start because somebody went out to collect an old account. You know, if you had a retainer and you didn't have an extra $500 or $1,000 to bill at the end of the file, you would eliminate a lot of claims, because it's when you send out that last bill and you try to assess it that they then raise an issue of negligence. And if you just either let it go, let the last $500 go, or have it in advance, you would not attract these, because we get a lot of calls that start from a solicitor and client assessment, and we often tell the lawyer, work it out, because as I said before, the first $17,500, the $5,000 deductible and the $12,500 levy is for your pocket. So if you're fighting over a $600 bill, what's the point? Just work it out. Don't go to assessments. Just write it off and get out of it. Nothing good can happen on an assessment, ever, in my experience. It can only...
Oh, yes, it can. The judge doesn't have to deal with it then.
All right, well, if it goes to a judge, fine, but assessing accounts down below is a very dangerous game for those reasons.
I think our time is up. I want to thank you. Hopefully we've been of some assistance.